Super. So, welcome everyone to our webinar, which features a number of mediators from our mediator group here at 39 Essex Chambers. And thank you very much for joining us. We are recording this, and this will be available later on if you would particularly like to watch us again. And in the next hour, we are going to spend some time discussing some of the topics that have come up in our respective areas of specialism, as well as some general topics that cut across all forms of civil mediation. We would love to answer your questions as well. So please do ask us anything at all that you'd like. There is a Q&A button at the bottom of your screen. Do pop your questions in there, and we will take some time in the second half of the hour to answer those questions. So I wonder if we might start with some introductions. I'm Kelly Stricklin-Coutinho. I'm a barrister and mediator here at 39 Essex Chambers. My specialism is commercial disputes, and I'm also the chair of the Civil Mediation Council. Wonder, William, could I ask you to introduce yourself next, please?
Yeah, afternoon, everyone. My name is William Norris. I'm also a barrister in 39 Essex Chambers. These days, I mostly sit as an arbitrator or chairing sporting tribunals and as a mediator.
Thank you, William. Neil?
Good afternoon. I'm Neil Block. I'm a King's Counsel practicing from 39 Essex Chambers. I still act as a barrister or counsel, but also I do a lot of work as a mediator and arbitrator in a range of group and individual claims.
Thank you, Neil. John?
Well, good afternoon. Unsurprisingly, I'm also a barrister at number 39. I spend most of my time these days dealing with arbitration and mediation in the planning and development field.
Thank you, John. Katie?
Yes, hello. I too, surprise, surprise, I'm a barrister and mediator from 39 Essex Chambers. My main area of practice is really court of protection in serious medical treatment cases, but I mediate a wide range of public law disputes, both with a monetary value and without, and in the court of protection. And I've also got quite a lot of experience of mediating neighbour disputes.
Thank you, Katie. And last but not least, very much not least, Olivia.
Hi everyone, I'm not a barrister at 39 Essex Chambers, but I am the ADR clerk alongside Chris.Jones, and I am also a qualified mediator.
Brilliant. Okay, thank you very much for that. And let's kick off with a question to our panel. So let's start with this. Why do we need mediators? Can't the parties, for example, in the civil liability field sort out their own problems in a JSM? And I wonder, William, do you have a view on that?
Yes, I mean, mostly they can sort out their problems, and if they can, they should. But sometimes they can't, and in any case, a mediator may well help the parties to move towards an agreement they might otherwise get to eventually, and can be a particular help if the parties are at odds with each other, or there's some special sensitivities arising by virtue of the personality of the lawyers or the personality of the parties. So I think mediation is always going to be potentially helpful. And I think a mediator who can bring something to the party in the sense of being able to encourage the parties by virtue of their own experience or personality is probably well placed to provide a useful and cost-efficient service.
Katie, I can see you've got a view on that as well. Sorry, Neil, we'll come to you next. Oh, Katie, we can't hear you.
Sorry, I didn't mean to put my hand up. Go to Neil.
Super. Neil, then, all yours.
I was just going to say that there can be cases where having a senior, respected, independent person can give confidence to one or other party who feel that they're getting nowhere, and that sort of additional help just breaks the deadlock, and it can create a sort of artificial door of the court where everyone has worked up to their big day, and they very much hope for an outcome that perhaps the JSM sometimes doesn't have quite the same effect.
I'm curious actually how much the civil liability world and the fact that you have JSMs and quite a collegiate approach to litigation generally might mean that going to a JSM is a bit more is something which is more likely to work than where you maybe have a broader spectrum of practitioners who aren't so used to each other and perhaps aren't quite so collaborative. And so perhaps mediation is particularly helpful in other areas, well, like commercial.
I think that there's no hard and fast rule. That's the great thing about mediation, that quite often you'll start off as facilitative, and particularly in personal injury, move on to evaluative, and that can help the parties. But it's certainly true in the more valuable claims that there's quite a small cohort of practitioners, and sometimes the reason why you move to mediation is that what you know about the person on the other side suggests that they might need a push in the right direction. But it's a very small percentage of cases where mediation is actually required, but it does have, and that's been my experience as a practitioner and as a mediator, quite a high hit rate in terms of resolving cases. So I would simply say that it's one of the weapons in the armory to be used as and when appropriate.
So on that topic of pushing in the right direction, then, how interventionist should a mediator be, if at all?
I think that probably everyone would say that one should start off as non-interventionist manner as possible, and then see what the day requires, what the parties require. And it would be very rare that you could actually move all the way through a mediation without giving either a very overt and obvious push in a certain direction, or being rather more subtle and getting people to think perhaps it was their own idea. But I would have thought that ultimately in commercial and in personal injury mediations, it is all about the bottom line. And the sooner that one can push parties towards talking figures and then justifying them, the better. And sometimes once that process starts, that there is sensible intervention to take one party to a sensible position, or both parties.
I wonder if others have views on this on our panel. My own view is that actually it's really important to have the combination of rapport with the parties in order to be robust and to intervene in a sensible way, because unless and until the parties trust you as a mediator, it's very difficult to intervene in an effective way. At least that's my experience, probably both as a mediator and as a party, actually.
I would say that it is important that the mediator gains the trust of the parties at an early stage. And I don't think that is going to be achieved by being overly interventionist at the outset. I think initial stages are to listen, and by discussion with the parties separately, to get a sense of what their expectations are, what their concerns are, what they see as the obstacles to progress. And I think through that, over time, you can then, as a mediator, decide that you might just give one or other side a bit of a push. But when I say over time, I'm anxious not to endorse those extraordinarily protracted mediations that some of us have experienced. Eventually at 11 o'clock at night, the parties think that they might as well just agree something. I really deplore that. I think you do need to be able to move things on. Yes. But at the outset, you need to be listening and getting a sense of what the real issues are between the parties, which won't always be obvious just from reading the material that's presented in advance.
Yeah, so it's about rapport and making progress. Yeah. John, and then Katie.
Oh, well, thank you. I was going to say that it's more relational these days. My experience of mediating over 20 years now is it has become more relational. That's why rapport building is so important. That's why I find time spent before the actual mediation day pays handsome dividends. In fact, we can shorten mediation day. And it's my common practice now to actually have Zoom meetings with the parties individually beforehand, so they get to know you. And then that element of trust can be built up, and you can accelerate that process on the day of perhaps getting down to what are the hard tacks that need to be chewed.
Thank you, John. Katie?
Yes, I would really agree with all that's been said. I'm going to be talking mainly about public law mediation, and often in those disputes, the parties have pre-existing relationships. And it's very dangerous, I think, for a mediator to go in and think, having read the papers, they know what the issues are, because actually there's a whole world of things that are going on that you have no idea about. And it's really important to try and work out what those are before you go in trying to make suggestions about anything.
Yeah. Katie, at the beginning, you indicated that sort of difference in your practice between things which might be about monetary value and which aren't. So how does mediation in the Court of Protection in particular differ from mediation in respect of disputes with a monetary value?
Well, it is really very different, because any dispute with a monetary value, the parties are able to carve up and decide between them whatever they find acceptable. When you're mediating in the Court of Protection, you're mediating about the rights of the third person who, by definition, lacks the capacity to engage in the mediation. So you're making decisions about somebody else, and so you are constrained by the law, the Mental Capacity Act. You can only mediate issues that the person lacks capacity in relation to. You can only come to a decision that would meet the criteria as being in their best interests, and there's a statutory list as to what you have to take into account. You have to take into account that person's wishes and feelings, and they have to be able to participate to the extent that they can, and that's not always straightforward to get disputing parties to agree how that can be done. So it's really important that the mediator has experience of the Court of Protection and knows their way around the legislation. And I would say equally for disputes about children, serious medical treatment disputes, which quite often come to mediation, it's important that the mediator understands the legal context in which those decisions are being made. And it's also one area of mediation where quite a lot of preparatory work needs to be done by the mediator with the party. So the mediator can have to be quite interventionist at that early stage in terms of, have you got a capacity assessment? Have you got this piece of information? How are you going to engage with the person so that we've got their wishes and feelings, etc. And so that needs to be handled quite sensitively for all the reasons we've articulated earlier about not being too interventionist early on. For a mediator, it's quite a difficult balance to get there.
And just thinking about that sort of difference in approaches and areas, I mean, John, what marks out planning and compensation mediation, for example, from other areas?
Well, there's an overlap with what Katie's just been saying, because really one's dealing with a very, very different situation from traditional litigation. Yes, there are relationships, but oftentimes you're brought in because those relationships have either broken down or relationships need to be created. So what you're doing is either trying to square circles or dig people out of ruts and mindsets. And on top of that, there's the whole issue of governance and lawful decision making and the need for consultation, which is why I said earlier about time spent rapport building. I've found from experience over the years, the more time you can spend with people, even if perhaps an action group aren't an actual participant in the mediation itself, yet they feel empowered because they've been listened to. So you're as much a diplomat as you are a mediator.
Right, I'm going to ask a different question, and it's a controversial one. I have a very strong view on this. I would love to know what our panel think about plenary sessions. I see William has unmuted.
Yeah,
and Katie's enthusiastic. Yep. What do we think?
I deplore them. I think they're absolutely dreadful. I mean, the parties absolutely need to have set out their case in advance and exchanged it, and they need to be able to address it, at least with the mediator or with the other party, if the other party wants something explained that they haven't understood. But as a rule, all a plenary session does, it's an exercise in showboating by the lawyers on one side, and it is likely as not to drive a wedge between the parties, an even further wedge than existed, which led them to come to the mediation in the first place. So I think they're a very bad idea. I mean, I have particularly unhappy experience of mediation plenary sessions in the last 2 years, and the mediator at one stage saying, well, I think I sometimes find it helpful to have an oral explanation of what goes on. If you're the decision maker, if you're the judge, yes, I quite agree, an oral exposition is helpful. But I absolutely do not need to have my opponent tell me how strong they think their case is, or to suggest how weak they think mine is. And to hear that advertised at a plenary session serves only to make the prospects of success at a negotiation negligible, in my view.
I can't imagine any lawyer has listened to what the other side has said and has said, oh,
Oh
actually,
my
yes,
goodness.
off I go.
I've got a rubbish case. If only I had known before, you know. And your clients are there and your solicitors are there. I mean, it's simply not going to happen. It serves to drive a wedge between the parties.
Yeah, it can put lawyers in a difficult position, actually, can't it? Yeah. Okay. Neil, what do you think?
I agree with William. I think that there's a certain type of client who loves to hear the boot being put in. They can dish it, but they can't take it. So it only raises temperature. I've just got one variation on the theme, though. I'm involved at the moment in a long running, in the sense that a case is being taken off in bite-sized chunks and mediated. And we occasionally have plenary sessions during the day where we take stock and we move things along, and that is a lot more helpful, because you're beyond the stage of setting out your stall. You're trying to work out where you've reached and how you're going to move forward. So I think one has to be careful with just tarring all plenary sessions with the same brush. And as I said at the beginning, there are no rules. And one of the skills of the mediator is perhaps to assess whether at some point during the day it would be a good idea to get everyone into the room and to see that actually they don't have two heads, and that they are really trying rather than being obstructive.
Yeah, with multiple parties, a stock-taking session like that is absolutely useful, but not for everyone to start advertising the strength of their case or the weakness of their opponents. That just always ends badly.
Casey?
I would agree with what's been said about setting out what your case is. I've had quite a lot of good experience of plenary sessions in cases such as cases for damages for breach of Article 2 or Article 3 after a death, where there's a lot of emotion in the room. The family would like to see who it is they're actually negotiating with. They'd like, often the clinicians are there and the apologies want to be given in person. And that can be a really helpful way of moving matters along, either at the beginning or during, or even at the end, once you've hopefully got some rapport. I would say in neighbour disputes, it's absolutely essential to get people in the same room, because they have a pre-existing relationship where they don't know each other and they think they're both monsters. And once you get in the same room and you see that you're human, then magic starts to happen. So I think it's not one size fits all, but certainly lawyers telling each other how good their cases and their opponents is, I'm not a fan of, but I think it is really useful in lots of different types of mediation.
How about you, John?
Well, I think I support the view that open sessions are rarely of much benefit these days. That's why I go back to this whole question of rapport building beforehand. It's very, very important, but I agree equally, you do need sometimes to have plenary sessions during the course of a mediation day, because there are sometimes issues that can be better discussed that way, equally, just as a means of actually building relationships between the parties again, or re-establishing them, or suggesting that perhaps coming out of a plenary session, two technical experts can have a chat about something separately without having to go and knock on each door and say, please, could you have a chat? So I think you just got to be very sensitive as a mediator as to how to use that card. It's gone are the days of following the standard approach to mediation day. It's so sensitive, and also as people get more used to the process, the more they are aware of the way in which the process can be manipulated. But I agree, the last thing one wants, as we said earlier, is for one lawyer basically to puff out their chest and tell the other side that their case is totally unarguable, which I always find slightly challenging.
I feel that it depends a bit on, sometimes when I do pre-mediation meetings, I will coach the parties that perhaps the grandstanding is not going to be very productive. And if you're going to have an initial meeting, there's got to be a purpose to it, and maybe it's around talking about your interest. It doesn't always work, I have to say. One reason I do like plenary sessions. I agree with everything that's been said about, all of the reasons why you've got to be very careful about having it, and there's no point in doing something which drives the parties further apart. But one thing I quite like is seeing the parties in a room together at some stage relatively early in the day, because I find it tells me something about how the parties interact across the table, which is quite interesting in a commercial context, because often they're people who have strong relationships already. And sometimes you find, there's one particular individual in that party and a different person in the other party who get on really quite well. And that might be helpful later on in the day when you're thinking about who you might want to bring together. And I think for my part, at least, the practice that I have, I found it helpful to see how the two decision makers relate to each other in a big meeting, because that's often a pair of people you might want to bring together later on. So I sort of like it, but in a way I don't really, it's not because of any interest in what anybody's got to say. It's more a relational thing. And I see we've got a comment as well. So this person says they deplore lawyer showboating in a plenary session. Quite right. But clients can feel the benefit of having the chance to be heard by the other side and to talk about why it matters to them. It's a fair point. And this person has found it works well where the client gets the chance to make an opening statement, limited to a few minutes each, and not making any legal arguments. So that's a good point, I think, with the mediator persuading the lawyers beforehand that their contributions are not required. Good luck with that in some circumstances, I would say, but yes, it is a good point. And then this person goes on to say that when lawyers refuse to keep quiet, it can be very revealing about the obstacles to settlement, which is also interesting, isn't it? Great. Okay, so let's turn to something else. Let us go back to our PI subject. So is mediation better or equally well suited to PI, do you think, rather than, say, contract or planning cases? And Neil, I wonder if you might have a view on that. Oh, Neil, we can't hear you at the minute.
Sorry, that had to happen at some point.
It's
certainly not better. It's better in some cases, and one of the skills of the lawyers is perhaps to try to judge in which cases assistance would be gained from a mediator. When acting as a mediator, it's quite interesting to see that it's usually because one party feels that they are being very reasonable and that the other side aren't, and that they've selected the mediator who they think is going to agree with them. And of course, that's not how it pans out at all. The mediator will agree they're being reasonable if, in fact, they are being reasonable. But one of the roles of the mediator in those circumstances is also to say, well, actually, you're not being as reasonable as you think you are. I wouldn't say, I can't speak about planning, but what I can say is I wouldn't say that it is better suited to personal injury than to, say, contract or commercial. What I would say is that in my experience, it is expected that there will be a mediation in contract and commercial, whilst it is still a small minority of cases in which mediation is used in personal injury cases. But the feedback that I get as a mediator, particularly in cases where there's more than one defendant, is that it can be of great assistance. In particular, sometimes one will sideline the claimant and spend a lot of time working on the defendants, and it brings people together in a way that having a 3 or 4 ringed circus in a JSM may not do. So it's horses for courses, but I would encourage consideration to be given as to whether mediation may be more appropriate than JSM, rather more than it is currently.
It's interesting just thinking about that, the idea of what the shape of the parties is and so on. I was reflecting earlier on, the practices that are now emerging in the commercial space, particularly for complex disputes, and how things might be more effective. And one of the things that is happening certainly in my area is that there's a bit more flexibility now about process design. So people are thinking about, should it really be a 1 day? Is there a reason, for example, to split it across 2 half days? Or are there other ways of creating a process which really suits the type of dispute you've got or the number of parties and so on? I think this idea of multi-party disputes is quite interesting. I suspect we have them in all of our respective areas in one way or another. But that idea of bringing everyone together in a way that's very effective, that you don't sort of lose any time because you've got one mediator and 6 parties and so on. But also that the parties who are involved in, say, one part of the case, but not necessarily every issue, are also fully engaged, but not wasting their time. But it's an interesting one. I think at the moment in the commercial space, what we're seeing more and more is a flexibility of process and a bit more thought going into the design of how the process can best suit that particular group of individuals or group of parties. I think we're also seeing a lot more proactive work before the mediation day itself starts. So picking up on those points that you said earlier around, pre-mediation meetings and so on. And, I hesitate to say it, but there's also thinking, I think, towards a mix of types of ADR as well. So we'll probably come on to that a little bit later. But this idea that it's one route or another is perhaps not quite going to be the way that we go in future for civil and commercial.
I've also never been involved in a mediation which failed to reach an outcome and not received a communication from one or other party asking me if we could continue the process, or whether this may help or that may help. And so that isn't necessarily what you're talking about, Kelly, where you have a structure that is more than the one day. It's just that it evolves informally, so that if the parties, or one of the parties at least, has confidence in the mediator, they try to prolong the process. And I would say that more often than not, it does eventually reach a consensual outcome by continuing beyond 5 o'clock on the day, or whatever it is.
Absolutely, which is that point around making progress on the day as a mediator to make sure that people get some value out of it and then can see something they can productively do with it afterwards if they don't quite get there on the day. Yeah, super. Okay, let's pick another slightly controversial topic. And Katie, I think this one is possibly for you. Do public law disputes really lend themselves to mediation? And if so, why? And of course, if not, why not? But I have a view as well, so I think it's a yes.
Yes, I mean, I think they do. There are, of course, such a wide range of public disputes. So some of them, I've had fair few mediations, those with monetary disputes, and those one can see much more easily how those lend themselves to mediation. And I think there's more of a willingness to mediate those kinds of disputes. I think there's less of an appetite for mediating your sort of more straightforward judicial review disputes. But I mean, I've in the last few months had a very successful, straightforward, would have been a straightforward community care judicial review, which was mediated much more quickly, much less expensively, and both parties were happy with the outcome. So I do think they're useful. I think it's really useful because sometimes what will unblock the dispute is not something that the court itself can grant, because obviously the court is pretty constrained when you come to JR, but there's a whole world of things going on, for example, between a social services local authority and a service user who've known each other for 20 years. So you can be much more imaginative. You can throw in things that the court can't grant, which will suddenly unlock the dispute and mean that the parties can move on. So I do think it is well suited to some aspects of public law disputes, and of course, court of protection is also public law arena, and it is very well suited to that.
Yeah, and I think the sorts of public law disputes that I've been involved in, the sort of commercial public side rather than the care side. But I think one of the key things from my perspective is that the mediator really actually has to understand the relevant public law principles that the public body has to apply, because there's no point trying to have a sort of a commercial or horse trading type of conversation, because there simply are constraints that the public body's got to work within. So it's an interesting one. All right. So a related area, John, how about something on planning? How do you mediate a planning case where there might be other interested parties than the applicant and the planning authority?
Well, as I've mentioned already, listening to those other parties and making them feel valued is so important. But the point I wanted to come back to is what Katie was just saying about this question of having to keep one eye on the lawfulness of the decision-making process, which is why oftentimes, with particularly with planning dispute following compensation ones, I'll come to compensation in a moment if I may, one's involved in a process that may take many months. It is going to mean inevitably either a particular matter going back to members, or at least there being some sort of reporting system whereby delegated authority can be given to actually, for example, grant a variation to a Section 106 planning agreement. So it's far less binary, if I put it like that. Now, you do not walk out with a settlement in the sort of the classic terms you expect to see them written up. But on the other hand, it can move a process on a lot more quickly. And I think that's one of the attractions. And as Katie touched upon earlier, particularly in the area of judicial review, there are certain aspects even of planning where, for example, reconsultation may overcome the issue that lies at the heart of that particular claim. Now, with compensation, it's slightly different because with compulsory acquisition, there is a process you go through. There is going to be a determination in the upper tribunal. So oftentimes you are brought in as the mediator when the parties cannot reach consensus. And oftentimes within a day, you can actually crack the differences and indeed get a settlement agreement drawn up, which near enough can then actually clear the decks for a formal order to be made by the upper tribunal. So I think again, it comes back to being fleet of foot, being alive to what the processes are, but also being expert in your understanding of them to know how to deploy suggestions. And I know we're going to come on to the issue of evaluative as opposed to positive mediation, but it's just raising the right course of direction at the right time, but ensuring that that is going to lead to a lawful outcome. Thank you.
All right, let's have something different now. I would love to hear from our panel. What have been your good experiences and your bad experiences, either as participants or as mediators? Who would like to go first? Katie.
I can go for a bad experience. When I was a quite newly qualified mediator, I think I had a 7-party dispute. I think one of them was legally represented, warring families, and there was no money to pay for pre-meeting discussions. And unsurprisingly, nothing happened other than people spending 3/4 of the day, which is a really important part of mediation, telling their story to the mediator so that they feel heard and understood. But that needs to happen before you get into the mediation room, mediation day, in my view, so that they're ready for negotiation and to move on at the beginning of the day of mediation day. And we didn't get anywhere. And that was a really salutary lesson to me about the importance of pre-mediation meetings, proper preparation, and it raises as well, I think, one of the issues that's raised in the question, one of the questions we've got, which is, I think, a real challenge for mediators, which is how to deal with inequality of parties. And my particular experience of that is where some parties are lawyered up and some parties are in person and often not at all familiar with the law or court processes, not professional clients. And that, I think, is really difficult for mediators to deal with.
Yeah, before we get on to the other interesting good and bad stories of mediations, I'm interested in that question that you've just referred to, Katie. And the question was, how do mediators here address the issue of power imbalance between the parties? It happens in discrimination, sexual and sexist harassment claims and employment claims, as an example. And it can lead to inclusion in conciliated arbitrated agreements of NDAs, which are helpful to the powerful party, but not to the party with the lesser power, in brackets, the claimant. So that's a really interesting thing. And it's something which comes up quite a lot, I think, this sense of how well equipped is a mediator to deal with power imbalance between the parties. I think for my part, it was very much a part of my training to deal properly with each of the parties as you find them in front of you. And there is also something quite important, I think, about managing, say, the discussions in a joint meeting to make sure that the process is genuinely fair and people genuinely have the opportunity to say what they need without feeling in too vulnerable a position. But I'd be very interested to hear if that issue comes up in practice for our other mediators and how it works when it does.
I think it's a very good question. I saw it on our list, where you've got one powerful party for whatever reason and the other party present particularly doesn't have lawyers in the example that was given. What the mediator's got to be careful to do is not to act as the advisor to the unrepresented, the weaker party. Almost human instinct is that we like to take their side and try to argue their case. I think you've got to be scrupulously careful not to do that. But on the other hand, you've got to try as best you can to restore the balance so that the parties are negotiating on as equal a term basis as you can. And that's not an easy balance to strike. But I think we just have to be careful not to take the side of the vulnerable, the party that's weakest, the party that, and we need to be there to support them, but not to become their advocate.
It's a really interesting one, isn't it? I've had something similar in a sport context recently, where it was a national governing body and a more vulnerable type of person that was, subject to the rules, whatever. And for me, it was also about process choice. So, if they're going to go into a joint meeting, defining very carefully what that meeting is about and what it's not about, and managing the expectations of both parties when they go in, so they know what they're going to get into and what they're not getting into, and that sort of thing. So I think there's a number of different ways of managing it overall, aren't there?
But there are particular challenges as well, because it's not just legal knowledge; it's an understanding of the confidentiality of most ADR processes. And if you're talking to a litigant in person, you have to be very careful, more careful perhaps, to make it clear the basis upon which statements are made by you and the other parties, and what they can take away with that. And it's a very unhelpful layer, in a sense, to have one room where you've just got the litigant in person, who is usually the aggrieved, and the other room where you've got properly represented parties who are probably the institution. I think you probably have to, as a mediator, make rather more notes than usual as to what is said in each room, because it may well come back at some point in the future. I've certainly seen it come back when I do sports appeals and things that should not be put into the appeal. So I would just say you shouldn't wholly discourage it, but you should be aware of the particular challenges.
And sometimes we're chosen as lawyer mediators because we are, we hope, good lawyers and have a view on legal things. But the reality is we are there to act as mediators, and with all of the appropriate actions that involves only. Great. Okay, let's go back to our discussion about good and bad experiences in mediations, either as participant or as mediator. I will tell you, my very first mediation as counsel, before I trained as a mediator, by the way, I was the absolute horror story of a barrister. I turned up, I was combative, I explained all of the reasons I was right, with my leader who agreed, but that's what we did. I'm sure we were very disruptive, and I did later on go and apologise. Once I had qualified and understood just how disruptive I had been, I went and apologised to the mediator, hoping, of course, that he didn't remember me. I'm sorry to say, even though it was many years in between, when I emailed him and said, do you remember that mediation? He said, yes, I remember it. So I thought, right, okay, I really was disruptive. Anyway, I'm obviously a reformed character now. I do it better now, but it's easily done. Any other thoughts on good and bad experiences?
I've got a sort of good experience that I've had twice, where we spent the whole day adhering to the tenets of a facilitative mediation. In both of them were damages claims, and we reached a point where we were within a half an hour or so of when everyone said they had to go. And I said in each room individually, well, it looks like we've reached the end of this particular road, but would you like to know what I think? And I'll only tell you that if I go into the other room and ask the same question, and if you both say yes. And I've done that twice. And on each occasion, both sides have said yes. And on each occasion, they have accepted my view as being a view that they could live with, although it's fair to say one of them said, I think you're wrong, but as we're all here, I'll agree. And do it with bad grace. But generally speaking, if it's back to the point that was made at the very beginning, if you have gained the confidence of the parties during the day that you understand their case and also their feelings, and that they do want to reach an agreement, but one that they can live with, then that's an experience that I would say is a good one.
Absolutely, absolutely. And I wonder how common the experience is for other mediators on our discussion, but I sometimes find that when I ask a question or I reality test a bit, there's a sense in the room, particularly amongst a practiced negotiator, of, is this mediator giving a subtle view? I'm told that my face betrays what I'm thinking sometimes, so perhaps that's contributing to it. But isn't there something interesting about when you go into a mediation as a party and the mediator's asking you some questions and you kind of wonder, is this coming from the mediator's view, or is this something that's come from the other room, and so on. So I find that as a mediator, I have to be very careful about how I phrase things and why, and also to try to sort of at least look neutral if I think it's a dud argument. Any other good and bad stories before we move on?
I'd like to deal with the unexpected, because that is the free sort of excitement that sometimes you really do not want to have in a mediation. But I have a good news experience to share. I was dealing with a mediation deal with compulsory acquisition of some agricultural land because of contamination from asbestos covered pipes. And we had stuck, because the acquiring authority had a cap on how much compensation they could pay. The farmer in question, so that was not nearly enough for the loss of the value of his land. And I remember sending him off just to have a walk around, actually find it was the centre of Birmingham. And I said, can I just leave this thought with you? If I was able to include a provision whereby you could acquire your land back once it's been remediated, would that be acceptable? He came back and said, yes. Now, the likelihood of it being successfully remediated to get his red tractor label back was pretty remote, but it then unblocked the pipe and we were able to negotiate the solution. I might add, it's a classic mediation where, of course, settlement terms took a rather long time to get resolved, and it was a very late night journey back from Birmingham to home. But I thought I'd just share that because it just came out of nowhere and it made all the difference.
And isn't it interesting what unblocks things sometimes? I've had a couple where, there's been a bit of a negotiation over, say, an apology or wording of something that's going to go out in public, and the wording that I'll hear in one room, I think, God, I wouldn't agree to that, lands perfectly well in the other room, and off they go. They're happy with that, and then they can move on to the rest of the discussion. So that's an interesting one as well. Okay, so before we move on to some other questions, I'm conscious we want to talk about facilitative mediation and evaluative in a moment or two. But Olivia, can I bring you in and ask you a question? So I think you would like to tell us, we've been talking about various types of mediation, and we've obviously launched our fixed fee scheme recently. I wondered if you might tell us a bit about that and some of the other things that you think might be interesting for our audience.
Of course, thanks, Kelly. So as you can see from the wide variety of our panel, 39 is a large multidisciplinary set that has a strong cohort of mediators. And to make everyone's lives a lot easier, we created a fixed fee mediation scheme that provides easier, more efficient access to our mediators at cost reflective of the parties' dispute. So the scheme has been created so that parties know exactly where they stand as they come into the mediation, and to make sure they have certainty over their costs, which I think we can all agree is really important, especially as we're obviously seeing more and more mediation inquiries. Mediation is growing, especially after the changes to CPR rules. People can now be ordered to mediate, and often they don't necessarily know how that process works. So that's where me and my colleagues come in hand, to be on hand to kind of answer any queries, but then also it's easy access on our website. I think Kieran might be able to share a QR code to where our fixed fee scheme actually is, which kind of breaks down all our areas of law and shows, depending on the area of law and the value of the dispute, how much the cost would be for one of our qualified mediators. The cost is generally a fixed cost that encompasses preparation. So it's generally 4 hours of preparation and an 8-hour mediation day. But of course, flexible to if the parties believe it might only take a half day or might even only take a few hours online. That's when it might be better to have a better conversation with me and the team to see how the costs can be adjusted to that. But yeah, it's generally a space for parties, representatives or lay clients to go to quickly see how much one of our mediators might cost, and then they can come to us and say, we want X using your fixed fee scheme, or we just want to mediate, who can you recommend using your fixed fee scheme? So yeah, it's purely there for the benefit of the client to make the whole process a lot simplified, as that's what mediation should really be for, really. On the screen, you can also see a QR code to our podcast series, which most of our mediators here were also a part of, broken down again in our areas of law and going into a bit more in depth in those areas of law. So we've got public law, civil liability, planning and commercial.
I think we had a very jolly time recording our podcast series, didn't we? And actually, on that note, one of the things that I noticed came up in all of our different areas actually was around this idea of facilitative and evaluative mediation. We've touched on this already, but we do have a question specifically about it. So I'm going to turn to that one now, which is that the person would like to know the panel's positions on facilitative mediation where the parties come to an agreement versus evaluative mediation, where the mediator makes a determine on the strength of the parties' positions, and has said here, it sounds like plenary sessions may include an evaluative element in an otherwise facilitative mediation. Do panelists find one form more effective than the other? And I think my starter for 10 is I tend to see this as a bit of a spectrum. So I think, like Neil and William have indicated earlier, I wouldn't myself go in and start evaluating. My preferred approach is to start with a facilitative approach, not least because I want to know what the parties actually think and what actually matters to them before anything else. But I also sometimes wonder, when you're particularly if you're in a specialist area, parties are looking for a sense of robust reality testing. And I suppose you go from that facilitative approach to really robust reality testing with the parties to potentially, if the parties ask for it, as Neil has indicated, that sense of giving a view. But what do our panel think?
Well, I set out that I think the norm for most successful mediations would be to start as facilitative and, as it were, see how the day goes. But in the civil liability group in Chambers, which deals with a range of personal injury, clinical negligence, insurance, and the like claims, we do offer an entirely separate service, which is an evaluation, a neutral evaluation. And I wouldn't view that as really within the mediation offering. I would view that as a separate offering. It's a bit like in the old days, it used to be written into some professional bodies' rules that you get a Silk's opinion. So I see that as slightly different, and I don't think it automatically has a great role to play in mediation in terms of starting a mediation by saying from the very beginning, this is what I think. I don't think that's helpful. I don't think the parties like those kinds of views imposed. And indeed, we do limited preparation as mediators. And I think it's one thing at the end of the day, when you've had an opportunity to properly understand, if you're asked to, and facilitation hasn't been enough to convert, but to start the day is not necessarily the most helpful way to proceed.
It's interesting, isn't it? Because that's sorry, William, go ahead.
No, you go ahead.
I was just reflecting on the fact that, as Neil says, that we're given limited information as mediators, that often we're given what's supposed to be useful for the purposes that the role that you play as a mediator in the mediation. You're not being given all of the information that you would want or need necessarily to give a view as a lawyer. So that's an interesting dynamic for me. But go ahead, William, what were you going to say?
No, I completely agree. That's why I think the mediator's role, certainly for the in the early part of the mediation, is to listen and to acquire a sense of the strengths or weaknesses of each side's case, but to recognize that you are there to help the parties reach an agreement. That's your only role. And I think sounding off early on about what you think is a good point or what you think is a bad point, it isn't going to work. I think as the day emerges, progresses, I don't want it to be too long, by the way. I think taking hours over these things is always a bad mistake. But as the mediation develops, you will both have gained we hope, gained the trust of the parties and gained a sense of the strength or weaknesses of each side's positions. And if you are an experienced practitioner who knows what you're talking about, then it may well help the parties if you do give a view, however informally, about what's a good point and what's a bad point. But you have to do what the parties want against the context of you're there to try and help them achieve agreement. That's the service we're there to provide. But it's kind of a waste if you're, let's say, in a personal injury case, you have Neil as your mediator. You've got senior juniors or middle-ranking juniors on both sides, and solicitors and clients and so forth. I mean, it's a real waste of a facility if at some stage during the day, if there's any doubt about a point, you don't get Neil's guidance on whether it's a good point or a bad point. So I think you do what the parties want against the imperative, which is to try and help the parties reach an agreement.
Mm-hmm. So let's pick up on early neutral evaluation, and Neil, your indication that it's something quite different in that context. So is anyone on our panel in favour of E&E, and if so, why?
Well, I am, but I think it depends on context. I mean, compensation is being deployed for some while, oftentimes using a surveyor or a surveyor mediator in that role. But there may be a particular point of law which may have to otherwise be determined as a preliminary issue. So using E&E can be very, very helpful in seeing the extent to which the matter can be resolved without contested hearing. I think it's harder when it comes to matters of opinion and judgment, and particularly in the planning context. Oftentimes they are more subjective than objective. So you have to be very, very careful for express a view.
But Neil's point is not the same thing as the mediation. It's a separate process. I see how early neutral evaluation can be valuable to the parties, but I would see that as being entirely distinct from mediation. Yeah.
I mean, what we do know that with our sort of colleagues at the family law bar, there is a process now whereby they often have a neutral evaluation in the morning and then a mediation in the afternoon. That's on financial settlement matters where things are much more clear cut. So I think we are at one, Kelly, that it's a very, very light hand that is played, and only when you've gained sufficient understanding, not only the parties, but also the issues and the extent to which it's going to lead to a constructive outcome.
Mm. So just while we are talking, I'm just going to mention that we've only got a few minutes left. So if anybody's got some burning questions, do drop them into our box below. And just going back to this point about E&E, I think it's very interesting, isn't it? Because once you've given a decision of some kind, it's, I think, quite hard then to return to a position of true neutrality. So I've heard, for example, some judges talk about how perhaps it might be helpful to have an a type of evaluation by one person at some stage that steers the parties, and perhaps if there is anything left still to deal with, then perhaps that's what goes on to get mediated, but by a different person. And I think there is something interesting, isn't there, in this idea of our neutrality as a mediator, and how evaluative we can really be. That I think the process of the E&E involves doing things in a particular way that perhaps isn't quite conducive to mediation. So perhaps that separation is helpful. Yeah. Okay. We've touched also on pre-mediation meetings, and I suppose that also implies preparatory work. I'm very interested, and perhaps I'm just being a little curious, but I'm interested what other mediators ask for in terms of preparatory work and how important it is. For my part, the thing that's really important to me is to listen to what people have got to say, because I'll read anything pleadings wise and documents wise that people want to provide, but that's not normally where the meat of the issue is in the types of mediations I'm dealing with. So I'm always interested in the conversation that you can have with the parties separately beforehand. And also, I mean, there's always something really, really interesting and valuable when you say to the parties, okay, what is it you want only me to know at this stage? There's always something interesting in that, which often ends up unlocking the dispute later. But what do others ask for? I mean, are you keen to have an evidence bundle or written statements of position, or what do you like to see, Katie?
I think, as I've mentioned earlier, with quarter protection mediations, you have to ask for capacity assessments, etc. There are some technical documents that you've got to hit, but otherwise, I don't really necessarily ask for anything. I just say to the parties, what do you think I need to know, and what are the issues that you want to mediate, and what's your view about them? And whether you set that out in a position statement so that the other party can see it, and then you have a discussion with me before we get through to the mediation day, or however you want to do it, I don't mind. But I'm not a huge fan of the mediator having to read, a trial bundle or all of the pleadings or whatever it is, because we're not decision makers. It doesn't really matter what we think. The important thing is to understand what the parties want to do and what they think.
And just reflecting on the sort of the equivalent in the commercial context, I mean, for me, the contract is obviously quite important, or if there are pleadings in play. But the thing that's really interesting is the context of that particular issue. So are there other relationships between those commercial parties, or is there a wider deal that's on, that sort of thing is quite interesting. And then also the significance of that deal in that particular industry can be really interesting too. Any other views?
I would say I'd like to have a core bundle first with position statements, short position statements. And then to pick up on John's good point earlier on, I would like to have, in advance of the mediation, a discussion with each party separately, just to get a sense of what they really are concerned about, what they hope to achieve, and what they see as the possible obstacles to a successful outcome. But I would like to read. I just like to read as it were. I was always taught, in any case, read the pleadings first. I would like to read the written material first. That's to say, pleadings, evidence bundle, but not everything. Just a core bundle, then position statement, and then have a conversation with them.
A refinement on that, or a plea, is mediation is becoming rather like in the old days briefing council. Everything turns up the afternoon before, and I think it's quite important that if you want to get the most out of the mediation, the mediator should get whatever he or she requires sufficiently beforehand that they can read it and then contact the parties. But getting position statements, as I say, at 4 or 5 o'clock the day before with bundles isn't the most efficient use of your mediator. So in terms of preparation, I think almost as important as what you give them is when you give it.
I unreservedly agree. So one of the things I tend to do is to say it needs to be there by such and such a time, and I will not read something that comes in within 48 hours. I'm very sorry, that's just my practice. You may think I'm being grumpy about it, but that's what happens. And that way people do tend to realize that actually it needs to be got to us in proper time.
Because it makes our preparation more effective.
Yeah, otherwise you're not providing a proper service.
Yeah, I mean, that's why I think good position statements, and I do emphasize good, and also short position statements, as Neil said earlier, can be really, really helpful. The other thing I found with certain disputes, compensation being one in point, is some sort of draft order, just so you know where the parties' differences lie, because you may have to mediate, spend more time mediating the actual wording of it, can be very, very helpful, and certainly speed up the process of distillation of the issues that need to be resolved, or those where the parties need to go away and come back again.
And I would also just add, I think the value of having somebody like Olivia to help us out with all of the important things like who's actually attending, et cetera, is all very helpful too. If anything, Olivia and people like Olivia who assist mediators are sort of the engine room. Super. Okay, so we have got exactly to time. Thank you very much, everybody, for attending. We've enjoyed answering your questions, and I hope it's been interesting for you as well. Just to note, we've obviously had our podcast series. If you'd like to find them, those QR codes that were up earlier will take you to those. There are, as Olivia says, podcasts on each of our individual areas. I'm not sure if our art and heritage one is up there as well, but perhaps that can be found on our website too. And if you've got any other questions, then please do feel free to be in touch with us. So thank you very much, everyone.
Thank you.